Welcome to Family Law Uncovered, a new series of podcasts from Thursfields Solicitors, one of the leading law firms in the Midlands. My name's Jill Roberts. I'm a senior associate in the Family Law department here at Thursfields, who specialises in family law.
And my name's Hannah Nicholls, an associate director and mediator here in the family team.
Joining us in this episode is Charmian Jackson. She is a barrister at St Ives Chambers, a deputy district judge on the Midlands circuit. Charmian also conducts private FDRs and early neutral evaluation.
So Charmian, we really want to dig into today a little bit about your life as a barrister and what you do on a day-to-day basis. So tell us, what does a typical day look like for you?
Hi Hannah, hi Jill, it's lovely to be joining you. There is no typical day in the life of a barrister, and that's one of the reasons that I love the job. From one day to another, I can be drafting paperwork or I can be appearing in court hearings up and down the country. Some days I'll be reading papers to prepare cases for court, or I might be meeting with solicitors or clients to discuss their cases in advance of an upcoming court hearing. But the vast majority of my days are spent in court hearings themselves. That could be physically attending at a court hearing, or following COVID, quite often it can be a remote court hearing, where we can either be doing that from the comfort of our own home, or from a solicitor's offices, or even from my own chambers. So every day is completely different. Sometimes those court hearings can be quite short, and I could be with the client for only 2 or 3 hours. Other times it's a whole day where we're at court from 9 o'clock in the morning through to sorting everything out and finally finishing at 5 or 6 o'clock in the evening. And so there's no typical day, but every day is interesting and every day is different, getting to meet lots of different people and trying to help them navigate through their legal issues. The types of work that I do is primarily in relation to financial remedies. So that is helping people resolve the division of their financial resources after a divorce. And I also do lots of cases involving private children law. So that's involving disputes between separated couples about where their children should live and what time they should spend with each parent.
And do you have a favourite, finances or child arrangements?
I really enjoy doing both areas of work. About 70% of my practice is financial remedy work and about 30% is private children work, and I like that balance. But I enjoy the fact that I do both areas of work and that it means that I can help clients who have disputes potentially in both areas to help them resolve all of the issues which are going on in their family following the breakdown of a relationship.
It's good that you get that variety. And what about the challenges that you face as a family law barrister? Tell me about those.
There are lots of challenges, but they're ones that I really enjoy. That's why I do the job. I like the fact that you meet lots of different people on a regular basis. But the challenge that comes with that is that often you may be meeting a client for the first time on the day of their hearing. Sometimes you might have met them the week before, but often it's on the day itself that you might meet them for the first time. And you are there to try and advise them and to try and help them at a very difficult time in their life when they are making important decisions which may affect the rest of their future. And so it is a challenge to be able to build up a rapport and trust with that client in a very short period of time. But that's one of the reasons, as I said, that I like doing the job, is that I enjoy that challenge, but it can be difficult. And it's understandable that clients will have some reticence about whether they should trust you when they've only met you for the first time that day. I think some of that is helped when you work with excellent solicitor colleagues like yourselves at Thursfields, who will have prepared the clients well for hearings in advance and will also often have arranged conferences so that we can meet people beforehand. There are challenges that are also posed by the people that you're against. Sometimes you can turn up to court and the opponent who is representing the other party can be difficult or hostile, which isn't always particularly helpful in family law. And you can also face challenges with judges, because judges vary wildly in their approach to cases, or they can do. And so you often may not know how the judge that you're in front of would approach your case until you get there on the day and start to read the judge's assessment of the strengths or weaknesses of your client's case. So being able to adapt to that quickly and make changes to your approach if you need to do so is another challenge, but it's one that I really enjoy.
Jill, obviously we are both lawyers in the family team here at Thursfields. How does our role as lawyers differ from that of a barrister? So obviously a lot of our clients will ask what the difference is and ask why we instruct barristers. Can you tell us a little bit more about that?
Yeah, of course, Hannah. I think we've touched on quite a big area there, which we've just been discussing in terms of usually when you go to a solicitor's firm, they're your first point of contact, and they will be the person that you would normally go to and discuss everything up front, and they will become very involved with your case. They will get to know you, they'll get to know your issues, and they'll be able to provide that bespoke advice in terms of relating that to those particular clients. But the solicitors are the ones that would be involved in the day-to-day running of the case, the day-to-day preparation, and also helping the clients through the emotional side of things that they go through as well. And that would be on a more day-to-day basis rather than, as Charmian said, that barristers tend to become more involved when court proceedings are involved. So that would be where they would start to come in. I mean, sometimes we would instruct barristers when we need advice on a particular area of something. And so we'd have, as Charmian said earlier, we'd have a conference with a barrister about that, or normally they would be involved once court proceedings have been issued, involved in the advocacy side of things, doing that. And one of the things that we would ensure when we're sort of instructing barristers is that we help the clients feel reassured, to be able to feel confident with the barrister that we've put forward. And we do try and match barristers with clients as well, because we get to know the barristers quite well, and we get to know what their personalities are like and whether they would meet the client.
That's important, isn't it? To make sure that our clients do trust all of their legal team, and knowing barristers like yourself, Charmian, we are able to say, yeah, Charmian would be a great fit for this particular client, and that's really important. So Jill, obviously Charmian told us about the challenges that she comes across. Are your experiences similar in terms of those challenges?
Similar challenges that we do face with Charmian would be the challenges that we face with the courts at the moment. And they're very varied in terms of those kind of issues that we're experiencing with the courts in terms of, I mean, from our perspective, when we're preparing things, they're taking very long time to issue things. They're not getting back to us about things. It's quite challenging at the moment from that perspective. Is there sort of challenges that you potentially face, Charmian?
I think, Jill, that you're right, that there are challenges in relation to the court, perhaps more so now than there were before the pandemic, albeit it's not a case that the pandemic, I think, is solely responsible for issues. But the courts do have backlogs still left from the pandemic. They struggle in respect of issues such as staffing and underfunding, which means that there are substantial delays in relation to court applications. As you've mentioned, it can take a long time for cases to be issued by the court in the first place, and it can then take a long time for cases to get to a first hearing where you might actually start to make some progress in the case. So those are challenges that have existed for a long time, but have only got worse over the course of the last couple of years. And I don't think that any of us working in the court system see a magic resolution to that immediately around the corner, unfortunately.
And obviously you sit as a Deputy District Judge on the Midlands circuit, dealing with both finances and child arrangements. What does that entail, and has that changed your perspective of the court system now that you're actually sitting as a judge in the courts?
Yes, I think it has. In terms of what it entails, my job as a Deputy District Judge is the same as a normal district judge's job, except I do it on a part-time basis. And so I will sit in different courts, normally for only 1 or 2 days at a time, to carry out lists of cases which require resolution. So I have the same decision-making powers as a full-time district judge, but just do it on a part-time basis. And I fit that in around my other work as a barrister. In terms of what it entails, it is a case where you attend court on the day itself. You're told the list of cases that you have to do that day, and you see the files, whether they're paper or electronic files, and you then have as much time as you can physically fit in to read those cases before then making determinations about them, having heard from the representatives that are before you. It's a very busy and fast-paced role, because you are then dealing with a number of cases throughout the day, rather than perhaps one or a maximum of two that you might deal with per day as a barrister. And so it is busy, and it is challenging, but it is interesting, and it's and it is a different perspective sitting on the other side of the desk, being the one actually making the decision. I think that has changed my perspective. I am more understanding now when I'm doing the day job as a barrister of the challenges which are faced by judges. I always have to make sure that I know whether judges have got paperwork, for example, because I now know how difficult it is to access the files sometimes. And I think it also helps me prepare my own cases better, because it ensures that I'm thinking about what a judge would think about it, to make sure that I'm preparing my client's case in the best way to present to a judge, having had the perspective of being one having to make the decision myself. I have a better idea now of what will help a judge make a decision and what information actually won't help them at all, and so what is better to leave out.
That's really interesting. And how about for us as lawyers? Do you have any tips for how we can prepare better for a judge? What would be your top tip?
I think particularly with remote hearings, having a draft order beforehand that you've sent to the judge is perhaps the biggest help that you can give them. The reason for that is that the judge ultimately has to make an order at the end of the day. And if you have set out a draft order, even if it's not agreed, or even if the judge isn't going to agree with everything you say in it, it provides a very useful structure, format, agenda for the hearing itself, because you can then ask the judge to effectively work through that order and highlight the points where you may need them to make a decision about something, or where there may be something controversial that you need to address. But it means that everyone is then working from the same document, and everyone has a useful structure to follow during the hearing. That's particularly the case with remote hearings, I think, where not everyone is in the same room together. Second to that, if it's possible to do a short position statement beforehand and to send that to the judge, that's always really helpful, because, as I've said, judges have very busy lists. They often won't have had time to read a full bundle, if it's hundreds of pages, for each of the hearings they have that day. And so a short position statement which summarises in a few paragraphs what the case is about, what your client's position is about it, and why, is a really useful document to help the judge get a quick understanding of what the case is about and what they need to decide. Anything more than about 3 or 4 sides of A4 and it's too long.
We've touched upon the change in the court's hearing system following the COVID pandemic. And we have some remote hearings, some in-person hearings, and what we call hybrid hearings. Can you talk us through a little bit about how the family law court arena has changed in that regard?
There are a lot more remote hearings now than there used to be. Prior to the pandemic, they were very much an exception to the usual rule of everyone being at court for every hearing. Now they are much more common. During that pandemic itself, at the height of it, pretty much everything was a remote hearing. Balance is starting to return now more, with more and more hearings now returning to being in-person hearings. But there are still a fair number of remote hearings. It tends to be in both financial cases and private children cases that shorter directions hearings, where the court isn't making any long-term or important interim decisions, will be remote. And those where there may be either important interim decisions to be made, or certainly any decisions being made at a final hearing where people may need to give evidence, for example, that those types of hearings are almost all now back in person. It doesn't mean that there aren't sometimes exceptions to that, and the court's encouraged to make decisions on a case-by-case basis as to what's most appropriate in any given circumstances. But as a very rough rule of thumb, children cases, you can expect now probably the majority of your hearings to be back in person, and with finance cases, that your first hearing will be remote. At your second hearing, which is called an FTR, some are remote and some are in person, and any final hearing I would expect now to be back in person.
Dealing with the clients, it's taken them a little bit of time to adjust to these remote hearings as well. I know as a result there's been certainly some instances that we could share with you that have caused us a laugh or two. Is there anything that you'd be able to share with us, Charmian?
Oh, there have been quite a few. It's been a strange process to adapt to remote hearings. And as you say, some people have adapted perhaps more naturally than others. I had one client who, luckily, this was only for a conference, so a discussion in advance of a hearing, but who did pretty much the entire conference from his bed, covered with a duvet, but clearly with no top on, which was interesting. There were good reasons why it wasn't appropriate to ask him to rectify that at that point, but having to have a conversation with a client at the end of a conference to stress to them the importance of being out of bed and dressed for a court hearing is perhaps a sentence that I never really thought that I would have to utter. But that's one of the things that has happened to me during the pandemic. In terms of sitting as a judge, obviously sitting at the other end of a remote hearing, in addition to video remote hearings, there have been lots of telephone remote hearings. And I'm sure you can imagine that those are quite challenging because no one knows when anyone is about to speak. And so there's a lot of everyone talking over the top of each other. But I did have one where the gentleman who was representing himself shouting down the phone at me about the fact that he was pulled over on the side of a dual carriageway, hadn't been expecting this call. And unless I allowed him 15 minutes to get home so that he could do the call from home, that he would be driving immediately around to his ex-partner's house and removing the children from her. So not the most productive start to a telephone hearing, but rather than getting into an argument with him and saying that the hearing was carrying on there and then, I allowed him his 15 minutes to get home. We reconvened the call, at which point I promptly imposed an order upon him, meaning that he was no longer allowed to remove the children from the care of his ex-partner, because he had directly threatened to do that during the course of the court hearing. So that's perhaps not the most productive way to approach matters from his perspective. The benefit of hindsight, I think he might have wanted to approach that one a bit differently.
I know certainly from one of my experiences is, how can I put this? Facial expressions, I suppose, is quite important with remote. I had a client that was very pleased with the result that had happened and was basically high-fiving the judge on a screen and giving kisses to the judge on a screen, which I suspect, had it been an in-person hearing, would have not happened. So that was rather amusing, but I think one thing to stress is that facial expressions are certainly seen more easily when you're on remote because you're on a screen. So controlling those facial emotions can be slightly more difficult in a remote hearing setting.
Oh, Jill, I absolutely agree. That's definitely right. I think when you're in a court hearing itself, people firstly can get away with pulling faces and the judge won't always spot them. But also as counsel, we would sometimes perhaps, although we shouldn't really, but if someone has been making a point for the 6th or 7th or 8th or 9th time, might start to raise an eyebrow at the judge about whether that was really helping matters much. But it's much more obvious, obviously, when you're on a remote hearing, and probably less helpful for the judge. Thinking about what the judge can see on a camera, particularly on a remote hearing, there are a couple of things about that in terms of my experiences through the pandemic. You would be surprised at the number of people who say to the court that they are on their own in a quiet space with no one there overhearing, and it then becomes obvious partway through the hearing that there clearly is someone else in the room with them. And you can tell, even if someone thinks that they are trying to cover it up well. But also I had a case, it's perhaps not a funny story, but it's a warning. But I had a case in which I was acting as a barrister for a client in a case where I was cross-examining his ex-wife about finances. We then found out that actually the ex-wife's father had sat himself outside of the door of the room in which she was being cross-examined, listening to everything that was happening, and had written a note to pass her under the door about what it was that she should be saying. Now, luckily, it got caught by the other side's barrister before anything happened as a result of that. But it's the kind of thing that it would be very easy to happen in the court, potentially not always to be able to know about. And I think it's one of the reasons why courts are keen for appropriate cases to be back in court now face to face, so that you don't run some of these risks that otherwise come about with remote hearings.
Thanks, Charmian. Obviously, that's a more sort of the perils of the side of remote hearings. Perhaps if you could just explain for some of the people that may be listening to this podcast who don't quite understand the seriousness of what that was, perhaps you could just explain for them why that was so serious.
Absolutely. So when someone is being cross-examined, if you were in a court hearing, actually physically in the court building, when you are giving your evidence, you're not allowed to be assisted by anyone else during the course of that evidence. Your evidence is meant to be your own. It's what you can remember. It's what you say is the right outcome for the court. It's what you say has actually happened or what you think will happen in the future. So in a court hearing itself, no one would be allowed to pass you notes. You wouldn't have any notes there to assist you. And it would be wrong if someone else can influence your evidence during the course of you giving that evidence. It would be like someone sitting at the back of the court and holding up a sign to the person in the witness box, telling them what it was that they were meant to say, which of course then it's not their own evidence. And what it meant in that case is that the other side's barrister, who was the one that saw this note that had gone under the door, had to consider her position and whether she was what we call professionally embarrassed, so that she wouldn't have been able to represent her client anymore. Now, because the note had only been on the floor, so there was no evidence her client had actually seen it or actually read it or said anything that was in it, it meant that she could carry on. But it put the other side's barrister in a very difficult ethical position, because she had to inform the court about that, because it's something that shouldn't have happened. It's something that she had to tell me about, something that the judge then had to consider. And it's something which ultimately potentially could end up prejudicing her client as well, because you then get into question marks about whether their integrity has been questioned at all, whether what they've said has been influenced inappropriately, and whether the judge could therefore actually even rely on her evidence at all. Ultimately, we managed to then settle that case without the court having to make a decision following that. And that note incident may have been a factor in it, but it could potentially have caused major damage to her case and caused difficulties with her being represented.
I think it's really important, isn't it, from both your perspective as a barrister, a judge, and from us as lawyers, that we must remember that despite the fact that some hearings aren't taking place in person, attending at court, we must remember that these hearings are serious and we must take them seriously. And they're just because they're being conducted either over the telephone or on the screen, that they're any less formal than if you were having to attend court in person. So it's really useful to sort of take stock of that and the different experiences and really remind our clients this is still very serious and important. Don't take it as a joke. You've got to turn up, dress appropriately, all of those things that we've talked about. It is well known that court proceedings aren't cheap, and ideally, court is a last resort to resolving matters in family law. Charmian, you are a private FDR evaluator and early neutral evaluator in family law cases. These are both alternatives to court. Can you tell us a little bit more about what they entail?
Absolutely. So a private FDR, an FDR stands for a financial dispute resolution appointment. And if you were in court proceedings, then it's the second potential court hearing, at which stage the court will try and assist you to negotiate a settlement with your ex-spouse. A private one just means that rather than waiting for a court hearing and it being done in a formal court setting, that you ask for someone who provides this service, so it's often another barrister, to act effectively like a judge in the court, but as an evaluator, so it acts outside of the court process, to provide you with their view about what a likely outcome would be in your case, in the hope that that enables you to resolve and settle your financial dispute with your ex-spouse. There are lots of benefits to doing it outside of court. In court, I've already referred to the fact that judges will have multiple cases in their lists every day and may not have much time to read those cases in advance. In a private setting, the evaluator will have had your papers normally at least several days in advance, if not longer, so they will have had lots of time to have read them and prepare them. And they are your evaluator for the whole day, or even 2 days if that's what you're paying them to do in a particularly complicated case. And so they have only your case to focus on, so they will be better prepared. They will have more time to listen to each party's submissions and what they want to say about it, so that's not rushed. And they are then available to the parties throughout the whole day to come back to address any remaining areas of dispute, or if the parties have narrowed down matters, to be able to give further guidance about how they might try and resolve any outstanding issues to reach a settlement. It also means that you can do it at the time that is convenient to the parties, in a location that's convenient to the parties, and you get to pick your evaluator rather than not finding out who your judge is until usually 4 or 5 o'clock the day before. And so you can be satisfied about their level of experience and what they're likely to be able to bring to your case. Of course, there's a downside in the sense that you have to effectively pay for that barrister for the day, whereas in court proceedings, once you've paid your initial application fee, there are no further hearing fees. But with private FTRs, you can often arrange them much more quickly than waiting 3 or 4 months for a court hearing. And the amount that you will spend on solicitors' fees in that intervening period will often be similar to, or even more than, the half of a barrister's fee that you would then pay, because normally with private FTRs, the parties would each pay half towards this additional barrister's fee to be available for that day to assist you to resolve matters. A lot of focus in financial remedy proceedings is about trying to reach a settlement with the other side. And so investing money in that stage of the process to do it really well with the best possible help, in my view, is an investment that's often worth making for parties if they have the resources to do so. In terms of an early neutral evaluation, it's effectively a similar process, but in a children dispute. So it's paying for an experienced barrister to read the papers in your case, to hear from both sides about what they say the right arrangement should be for a child, and then giving the parties their view about what they think a likely outcome would be if they took the matter to court instead, in the hope that it enables the parties to then reach an agreement between the two of them, rather than having to go through contested court proceedings. It is only suitable in cases where there are no safeguarding issues, so cases involving things like domestic abuse, or where there are alleged to be any harm having carried out by either parent to a child, wouldn't be appropriate. But where it's cases where both parties are perfectly safe and capable of looking after their children, but they just disagree about exactly how time should be divided up, and those are the cases that are suitable for that early neutral evaluation process.
I think these alternatives are really useful, particularly to speed up matters and to save costs. You touched on the private FDRs and the effectiveness of that, and it's the fact that they're more speedy than court hearings, or you can get them a lot quicker. And I had a recent case whereby we had a hearing listed for a Monday. And that's a financial hearing. And on the Friday prior to that, we were told that there was not going to be a judge. but this was quite late in the day, so around 3-4 o'clock in the afternoon. So we were luckily able to obtain or secure a private FDR evaluator for the Monday, and we were able to settle that case on the Monday. So that's a really, really good example whereby even though we were sort of let down by the court at the last minute due to no judges being available, we were able to quickly turn that around, secure a private FDR evaluator for the Monday who read the papers over the weekend and was able to help us in that case. So I think it's a really, really good example of how we can use alternative methods to deal with issues in family law and really try to turn things away from the court, which obviously then helps to reduce conflict between the parties and families involved.
So we've touched a little bit about private FDRs. I know certainly I've had cases where it's been appropriate to refer to arbitration as another option as well. Charmian, perhaps if you could just explain a little bit about that from your perspective as well.
Absolutely. So arbitration is a scheme of qualified arbitrators, so they have to go through special training and accreditation, where they can effectively carry out the role of the judge in court and make decisions that the parties agree will be binding on them. So the private FDRs and the early neutral evaluations that I talked about a moment ago is just someone assisting the parties to see if they can reach their own agreement. Arbitration is where the qualified arbitrator imposes a decision that both parties agree in advance will be binding on them. So it's similar to court in that way, but it's not an actual court process itself. The parties both agree that they will be bound by that decision, but then are then able to select their arbitrator. And it has the same benefits in terms of potential cost savings and saving in relation to delays in the court process that we've already talked about. But it just means that it has that binding effect on the parties outside of the court process, but still getting that decision that the parties ultimately want, potentially quicker and cheaper.
Here at Thursfields, we're obviously all those options are at the forefront of our minds, and we're always very conscious to discuss all options with clients so that they can make the best decision for them and the best decision for their case going forward.
So finally, Charmian, what would be your career highlight to date?
Whilst I'm sure some other people would talk about cases in the Court of Appeal and things like that, my career highlight, in the sense of it's something I will absolutely never forget and I will never do anything like it again ever, I'm sure, is that I appeared in front of the British Pigeon Racing Council for a client on a Saturday morning in an illustrious hotel just outside of Coventry, in front of a 27-member panel, the chair of which had a gavel. Now, for those that are not aware of the legal system, gavels, they're an American thing. We don't have them in the English court system at all. If you see a gavel on a TV drama, it's wrong. But this is the only time I've ever seen a gavel actually being wielded and being used to good effect, because 27-member panel, they can make quite a lot of noise. And I advanced a natural justice argument, which prevailed by 14 votes to 13, so that I managed to win for my client, combined with the fact that they had an excellent biscuit selection available outside of the room. So that is an experience that will never be topped in my book. So outside of family law, but I hope that it just shows that when I say that there is no typical day in the life of a barrister, I really mean it.
You've been listening to myself, Hannah Nicholls, and my colleague, Jill Roberts. Hopefully you've found our discussions on this topic have given you an insight into family law and you have found this useful. A big thank you to our guest, Charmian Jackson, barrister at St Ives Chambers. If you are dealing with a family relationship breakdown and would like more advice, you can find our details on our website. We will be back next month, again with Jill, who will be joined by Olivia Lee, also our colleague in the family team here at Thursfields, who will be discussing all things no-fault divorce, which was, of course, introduced in April this year.
Family Law Uncovered, an original podcast from Thursfields Solicitors. Thanks for listening.